Hi class, my name's Angela. I am juror number 7 responding to the case of the plaintiff Jennifer versus AU Hospital. I am ruling in favor of the plaintiff Jennifer. Her rights were clearly violated when AU Hospital sent her personal and health information in response to a subpoena when there was not a court order involved. Had the subpoena been court ordered, there would not be a case, because a covered health care provider or health plan may disclose protected health information required by a court order. The law states that a subpoena issued by someone other than a judge has to follow the proper notification requirements. These requirements include obtaining permission from the patient to disclose or forward their information. This requirement was not met. The hospital failed to ensure that Jennifer's protected healthcare information was okay to give out. They needed to notify her of the request so that she could have a chance to object to the disclosure and/or seek legal advice. HIPAA stands for Health Insurance Portability and Accountability Act. Passed in 1996 by the United States Department of Health and Human Services, HIPAA is a federal law that sets a national standard to protect medical records and other personal health information, also known as PHI. This information includes any demographic data that involves patients' past, present, or future health, physical or mental condition, any payments or history of non-payments, or the provision of health care to the individual. Basically, any information that can be used to identify a patient is not legal to give out without consent, and this usually has to be written consent. Some health information that can identify a patient includes any common identifiers such as their name, obviously, address, birth date, social security number, telephone numbers and fax numbers, email addresses, health insurance numbers or account numbers, license plate numbers of any car information, any implanted device serial numbers, a web or IP address, fingerprints. Now this one's interesting because a lot of new check-in processes in hospitals require reading fingerprints or palm scannings, and these can somehow get out, not sure how, but to identify a patient. Voice prints, I'm not sure how that one's possible, but it is on the HIPAA website, maybe from a recorded phone call. Any photographs or images from any studies or anything that they might have on file. It seems silly to have a list, but there are some that do not know what is not supposed to be shared with other people. Our text states that there are numerous policies, guidelines, regulations, and laws that limit access to what has been known as a patient's protected health information, PHI, which we discussed earlier under the HIPAA Act. Protected health information encompasses the details a provider collects regarding the patient's condition, treatment, or payment that identify or have the potential to identify the patient. Working in the healthcare field, it's interesting to see how easy it is to break HIPAA with a slip of a name in a phone call, or when we do not clarify who a person is or what they're calling for and giving out the wrong information, or even something as simple as mailing the wrong packet of information to the wrong patient, and that could have their name, address, date of birth, social security. Someone who it gets into the wrong hands could lead to fraud. There are plenty of examples of how HIPAA can be broken, but in this case of Jennifer versus AU, whoever sent out that information on the plaintiff probably got fired from his or her job, and that's how serious the situation is. So again, juror number 7, voting in favor of the plaintiff. Best of luck in the class, guys, and hope you are at least able to enjoy a little bit of your weekend with all the schoolwork we have. Thank you.